Hello everybody and welcome back to my English Law channel. So this video is going to be about exemption clauses in contracts. So we're going to consider the different types of contract, B2B or indeed business to consumer. We shall also look at the distinction between express and implied terms, examine what a breach would be, look at the different categories, and lastly at the defences that an exemption clause can offer, whether it's incorporated or not, the construal of the said exemption clauses, and the various statutory controls on exemption clauses. Anyway, so what is an exemption clause? Well, an exemption clause is something which says that a party is not liable for things that he would otherwise be liable for. Things would otherwise be considered breaches of contract. So there was the Photo Productions and Securicor case, 1980, and Lord Justice Diplock sat on this one, and this is what he had to say. A term which excludes or modifies an obligation, whether primary or general secondary, that would otherwise arise under a contract by the implication of law. Now, you might recall this case. So Photo Productions had a huge photo lab when photos had to be developed. This long before digital photos. They hired Securicor, that security guard company, that are people who deliver cash in transit to banks. And Securicor's job was obviously to keep the building safe, to prevent burglaries, but also to prevent things like fires, to raise the alarm if that occurred. Now, one Securicor employee, he was chilly in the building, so he had a brainwave, and he hit upon the genius idea of lighting a fire inside the building. And you can guess what happened next. It raged out of control and it burnt down the entire building. Now, Photo Productions were not elated about this, and they said Securicor has got to pay for the whole cost of the building being reconstructed. And Securicor pointed the exemption they had in that contract, which said that they weren't liable for anything that went wrong, any destruction. And well, Photo Production said, well, no, this is fundamental breach, because you're meant to keep the building safe, not light a fire. One of your duties would be to extinguish a fire if one broke out, or at the very least to raise an alarm. And what you did was so utterly asinine, so totally the opposite of what you're supposed to do, that this exemption clause will not cover it. Well, actually, it went all the way to the House of Lords, and the House of Lords found in favour of the defendant. Securicor said, nope, this exemption clause was there in crystal clear language, and Securicor is therefore not liable. If you wanted to be liable, you should not have signed a contract which contained such a clause. So how do these exemption clauses operate? Well, there are two different theories about this. The first one's the definitional theory, which says that exemption clauses must be handled like any other term. So you read the whole clause and try and find out what contractual obligation follows from it. So exclusion clauses simply say there are certain obligations that are created by the contract. So this is going by what would now be seen as a bit of a 19th century thing, the laissez-faire idea of contract, as in let it do what the state stands back. You can sign any contract you want, and the courts must uphold that. Freedom of contract. So almost a libertarian approach, or maybe anarcho-capitalist approach to it, which is a little bit out of fashion these days. Or you could have the more exclusory approach, which is to say these exclusion clauses are different from other terms, and that's because what they do is they remove liabilities that a party would generally be under. So the exclusory approach says that the state must intervene and not allow clauses which are unconscionable. The state needs to be a bit more of a nanny state. Okay, so there are a number of controls on exclusion clauses. There are some common law ones, such as whether they're incorporated into the contract or not, and the way that we construe them. There are also statutory controls, but I'll come on to those more in a subsequent talk. This is more about common law, this one. The Unfair Contract Terms Act 1977 is a statutory control of them. So incorporation, a contract is presented, it's signed, and everything in that is incorporated into the contract, usually. There's also reasonable notice. If you were told before you sign the contract or at the time of signing, then usually that will serve to incorporate the term. there could be a consistent course of dealing in which people frequently allowed some exclusion clause. Okay, so now let's go to the well-known case of Lestrange and Grawcobb, 1934. Mrs. Lestrange, she purchased a cigarette vending machine, and there was something in the contract to say, even if this machine is defective, we're not liable from it. Grawcobb sold it to her. Anyway, the cigarette vending machine didn't work, so she said this is ridiculous, so she sued on it. Anyway, Lord Justice Scruton heard the case, and this is what he said. When a document containing a contractual term is signed, then in the absence of fraud, or I will add misrepresentation, the party signing it is bound, and it is immaterial whether he read the document or not. That's the end of the quotation. So that's it. She'd agreed this contract that said that even if it doesn't work, well, Grawcobb is not liable for it. So there we are. Now, these days, that probably wouldn't work because, of course, Sale of Goods Act has come in since saying, no, it's got to be something which can be utilised for the purpose that the person bought it. All right, so there are some exceptions to this rule because, generally speaking, the signature is binding. If that term is in the contract, you signed it, or indeed you accepted the contract, you accepted it through behaviour, then the exclusion clause will operate. So a signature will not bind a person if there's been fraud, as the Lord Justice said, or there's misrepresentation. There was Curtis and Chemical Cleaning, 1951, about cleaning a wedding dress that was actually dirtier after cleaning than it had been before. I can't remember how there was fraud there. Or sometimes the document signed it just doesn't have any effect in the contract. Grogan against Robin Meredith, Plant Hire, 1996. Oh goodness, I can't remember. It's a sort of an employee of Robin Meredith, Plant Hire, and subcontracting and things like that. Sometimes it's a case of non est factum, as in it is not done, as in Saunders against Anglia Building Society, 1971. Now, you could have a reasonable notice of what the exclusion clause is. The person seeking to rely thereupon must have taken reasonable steps to draw the other party's attention thereto. This person's the proferens, the person who seeks to rely upon it. For instance, Parker against South Eastern Railways, 1877. Sometimes it's incorporated by reference. For example, Thompson against London, Midland and Scottish Railway, 1930. So it was on the ticket. You want to see the terms of carriage, and that's where you can get it, because there wasn't that is your contract really, the ticket, subject to conditions of carriage. What are the conditions of carriage? Which will refer you to another document where you can read it. Or indeed O'Brien against MGN Limited, 2001. So there needs to be a reasonable notice, as I said, prior to signing, or indeed at the time of signing. For instance, Ollie and Marlborough Court Hotel, 1949. There was some sort of exclusion clause, but he didn't see that until he got up to the room. There's a notice on the wall. Well, that was after he'd made the contract, as in after paid for the room or agreed to take the room. Or indeed Thornton and Shoe Lane Parking, 1971. Shoe Lane in London, it's there. I think it's by Cornhill, near St Paul's Cathedral. And the chap parked his car. You see the machine, and that is an offer. What you see on the screen of the machines, by introducing your coins to the vending machine, you've accepted the offer. And he was saying, well, I wasn't told in advance. Well, you were told at the time you made it, because whatever the term was on the screen. Now, there are some onerous clauses, and if they're onerous, then a party who's going to seek to depend upon them must make strenuous efforts to draw this to the attention of the other party. For instance, it'd be Thornton and Shoe Lane Parking, 1971, Interphoto Library against Stiletto Visual Program in 1988, and that's really just building on Spurlaw and Bradshaw. Now, signature incorporates these onerous clauses unless there's some extraordinary circumstances, such as Chemical Transport Incorporated and Exner Craggs Limited, 2000. So anyway, thinking of the contractual document, that will provide a reasonable notice. If the document is there, or there's a notice that has the clause in it, then this usually has contractual effect. For example, Chapelton against Barry Urban District Council 1940, or indeed Grogan and Meredith, which I previously mentioned. It could be in a course of dealing that the two parties regularly trade with each other. So if the exemption clause is going to be regarded as incorporated into the contract, the dealings must have been consistent and they must have been fairly frequent. Look at McCutcheon against David McBrain, 1964. McBrain is a ferry company in the Western Isles. It's now called Caledonian McBrain. So McCutcheon was regularly using a car ferry, and the ferry was operated by McBrain. And sometimes McCutcheon was asked to sign a document saying any damage to the car because of this voyage is the McBrain is not liable for that. But on some occasions he wasn't asked to sign it. Then one day the ferry sank. His car was wrecked, couldn't be recovered. McCutcheon himself got away without injury. But did McBrain have to compensate him for the car being underwater, being unusable, even though they could salvage it? On that occasion, he hadn't been asked to sign the exclusion clause, well, the document with that. So McBrain said, yes, but there was a course of dealing, and he often signed it. Well, often isn't enough, because it was inconsistent. If he'd signed it every single time except that voyage, then it might have operated. So McBrain had to pay compensation for the automobile. Sometimes they're dealings which are not regular, and they're probably inconsistent. There's no incorporation. For instance, Hollier against Rambler Motors, they had a maximum of 4 trades in 5 years. Sometimes the dealing is regular and consistent, in which case the term is incorporated. For example, Kendall and Sons against William Lillico, 4 times a month for 3 years. Or indeed Petrotrade Incorporated against Texaco in 2000. That was only 5 times, but over a period of just over a year. So how do we construe these exemption clauses? Well, I was George Mitchell against Finney Lockseeds, 1983. Lord Bridge decided this, and he said, on its natural and ordinary meaning does the clause cover the breach, whether fundamental or otherwise. Because sometimes there's a breach and actually the exclusion clause doesn't cover it. It doesn't envisage that eventuality. Or look at Persimmon Homes Limited against Orup and Partners Limited, 2017, where it was held, exemption clauses are part of the contractual apparatus for distributing risk. There is no need to approach such clauses with horror or with a mindset determined to cut them down. Because until the noughties, a lot of judges who were prejudiced against them seem to be trying to find ways to say that they are vitiated. So remember the contra proferentum rule, as in any ambiguity, is interpreted to the disadvantage of the person seeking to rely thereupon. Andrews Brothers and Singer, 1934, be a case, or indeed Horton against Trafalgar Insurance, 1954. So if you want to depend upon an exclusion clause, you'd better make sure that it's written in pellucid language. So the courts are less inclined to use the contra proferentum rule in commercial cases, because remember, the courts don't think that businesses need protection so much as ordinary people. Lloyd Neuberger heard the case KS Victoria Street against House of Fraser, 2011, and he had the following to say: the rules of interpretation, such as contra proferentum, are rarely decisive as to the meaning of any provisions of a commercial contract. The words used, commercial sense, and the documentary and factual context are and should be normally enough to determine the meaning of a contractual provision. So thinking more about how these things are construed, how they exempt liability for negligence. Courts are reluctant to permit broad exemption clauses which are trying to exclude liability for contractual breaches and failing in your duty of care. So what's negligence here? It's something that would be considered a breach of duty in tort, or not abiding by your contractual duty of care, especially if it's business to business as per Section 13 of the Sale of Goods and Services Act 1982, or business dealing with a consumer as per Section 49.1 of the Consumer Rights Act 2015. Remember, businesses have to exercise reasonable care and skill. Right, so look at this Canada steamship test. If there's a clause seeking to exclude liability for negligence, well, we'll see what was said in Canada Steamship Lines Limited against the King, 1952. So the Canada steamship test is, there's some doubt about that these days. So broad guidelines are not prescribed, and these are not prescribing rigid rules. So the court found in HIH Casualty and General Insurance against Chase Manhattan Bank, 2003. coming back to that well-known case of Persimmon Homes against Ove Arup 2017, Lord Justice Jackson said, "In recent years, and especially since the enactment of the Unfair Contract Terms Act, the courts have softened their approach to both indemnity clauses and exemption clauses. My impression is that at any rate, in commercial contracts, the Canada Steamships guidelines, insofar as they survive, are now more relevant to indemnity clauses than exemption clauses." So how do we construe these things? If the clause is trying to exclude liability for negligence, there is a tripartite test. So number one, does this clause particularly talk about negligence or anything close to negligence? For example, Monarch Airlines Limited against Luton Airport Limited 1997, where it said that any act or omission or neglect or default would not lead to liability, because in that case, Monarch Airlines plane had its wheel damaged because Luton Airport hadn't maintained their runway properly. But because of the exclusion clause, London Luton Airport was not liable for the injury caused to the Monarch Airlines plane. The second part of this tripartite test is the clause broad enough to include the sort of negligence that occurred. For instance, if it's talking about any liability or loss howsoever caused, therefore impliedly included by negligence, well, okay, that tends to favour those who are saying there's no liability here. But could the clause be too broad? For instance, if the clause is used by the defendant to exclude all kinds of liability, breaching the Sale of Goods Act or breaching an express term as well as negligence. So if more than one kind of liability is excluded, then the clause is not just about non-negligence liability. So perhaps that's not it. Say if you have a clause to say that any breach of contract, no matter how fundamental, even if we don't sell you what we're going to say we're going to sell you or provide a service remotely similar to what we said we're going to do, or even if we don't pay the money we said we're going to pay, well, we're not liable. That'd be ludicrous. You might as well not have a contract at all then. So if it's too wide, that will probably operate against those the proffer ends. So the Canada Steamship test, if negligence is the only liability that they're ruling out, then this clause will probably pass the test, as in White and Warwick 1953, or Aldersdale against Hendon Laundry 1945, EE Caledonia Limited against Orbit Valve Company 1994, or indeed Persimmon Homes against Ove Arup 2017. There are also limitation clauses which don't exclude liability, but they limit how much you'd have to pay. So a clause which only restricts the scope of the liability is going to be construed less stringently. For example, Elsa Craig against Morven Shipping 1983. Now there are exclusion clauses, and these sometimes help third parties. For example, Scruttons Limited against Midland Silicons Limited 1962, or the Euromedon, better known as New Zealand Shipping Company Limited, against AM Satterthwaite 1975, whereas the stevedores could rely upon some of the exemption of liability in the contract to say that even if they damage these goods, they're not liable, and that worked for them. There's obviously overlaps with the doctrine of privity. Look at the statute Contract Rights of Third Parties Act 1999, made it crystal clear that a third party can rely on some of these exemption clauses in contracts to which they're not party. So section 1.6, it makes it obviously crystal clear that certain exemptions can apply to third parties, or section 6.5. So third parties are particularly exempted in contracts for carriage by sea, if there's a clause to say that they are exempt. Okay, so next time I will look more about exemption clauses, and particularly about statutory controls. That's enough from me. So please book your online lessons with me in law and all sorts of other subjects. Goodbye.